Our court case is Madison versus Alabama. We're arguing the petitioner, which is Madison. The background of this case is
Vernon Madison shot and killed Mobile police officer Julius Schultz during a domestic disturbance call. Madison was convicted of murder and sentenced to death 3 times, in 1985, 1990, and in 1994. He was on death row after suffering a number of strokes that impacted his mental capacity. The court ruled in favor of Madison, finding he was incompetent to be executed. The Supreme Court then overturned the decision the same month, which cleared him for execution. There is still no final ruling. This case agrees with the Eighth Amendment because the Eighth Amendment states that there is no cruel or unusual punishment is allowed. Our argument states that after he suffered several strokes, he was unable to remember the situation. When he shot the police officer, he was not in the right state of mind. Later, he was diagnosed by doctors that he was mentally unstable. We know that he is not able to understand the things going on around him, and we argued that because of his dementia, which has very particular features, he's incompetent to be executed. If Madison is unable to remember the situation, how can he be executed for something that he is unable to comprehend? These court cases are similar to Madison versus Alabama. In Panetti versus Quarterman, Scott Lewis Panetti was convicted of murder of his wife's parents and sentenced to death. The court held that the Fifth Circuit's analysis was too restrictive under Ford versus Wainwright because it treated Panetti's mental condition as irrelevant as long as he had in some sense a factual awareness of the state's rationale. In Madison versus Alabama, the court also treated Madison's mental condition as irrelevant. In Atkins versus Virginia, since it last confronted the issue, the court reasoned that a significant number of states have concluded that death is not a suicide punishment for a mentally retarded criminal. This related to Madison versus Alabama because the court wants Madison to be executed for something he can't remember.
Our case is Madison versus Alabama. In this case, we are arguing for the respondent, who is Alabama, who wanted to uphold the death penalty in this case. Our argument is that it is not possible to prove that Madison truly does not have a recollection of the events that led to this case. He could be lying about his lack of comprehension and trying to claim insanity, as many previous petitioners have done. Even if he does not remember his actions, he still committed the crime of murder, which cannot be undone. Being unable to remember the crime does not negate the fact that he murdered a police officer. A court-appointed expert concluded that Madison did suffer from cognitive decline from his recent strokes, but found no evidence of psychosis, paranoia, or delusions, meaning that his plea for insanity should not be upheld.
This brain represents how Madison's brain was found healthy according to the court-appointed psychologist. As seen with the precedent set by the 1989 case, Penry versus Lanau, executing the mentally retarded is not cruel and unusual punishment under the Eighth Amendment. This noose represents one way that many people were executed. In the case of Hall versus Florida in 2014, it explains how IQ tests alone cannot be used as a rigid limit for determining intellectual disability, showing that more should have been done to prove that Madison did not have the mental capacity to be executed. This needle represents the lethal injection that is another way that many are executed. Furthermore, the case of Gregg versus Georgia in 1976 reaffirmed the court's acceptance of the death penalty of the United States. The electric chair is one more way that many people are executed.